Hello, everybody. Welcome to Practitioner Safe Harbor Exemption Laws for Complementary Alternative Healthcare Practitioners. Thank you so much, Julie Klein, for having the Trinity Health Freedom Expo this year. I know it's quite a time in the history of the country and of the world, and having this virtual expo is exciting, making the best of all worlds, and it's a great opportunity to be here talking with you all today. So today I'm going to present a PowerPoint presentation, and it will be mostly geared towards the conversation about practitioners regulation for practitioners that are not conventionally licensed healthcare practitioners, such as herbalists, homeopaths, Qigong practitioners. And also I will do some discussion about federal issues that are current right now, and a little bit about health freedom in general. My name is Diane Miller. I'm the Director of Law and Public Policy for National Health Freedom Coalition and National Health Freedom Action. And I'm here today representing both organizations, but it is an educational effort that we have. And if you have any questions, please contact us on our website at nationalhealthfreedom.org. So I hope this works. Here we go. The most important thing that I have worked on over the last 25, 30 years is the freedom to heal. Freedom to heal ourselves, freedom to heal each other. And I really didn't know that there was a problem about whether we could heal each other until I started working on cases where practitioners were being shut down or families were blocked from having choices about what they were going to use with their doctors. So I have become extremely passionate about the freedom to heal in many, many areas. Since I am an attorney, I'm also very passionate about law. In our country, we have a wonderful setup where we can make laws and they can protect us and they can preserve our personal freedoms. They can put restrictions on entities that are harming us. And I have been a very big advocate of reviewing laws that don't work for us anymore and revising them and changing them if I think that needs to be. And of course, as we've seen recently with Supreme Court cases, they have to uphold the law, but sometimes they kind of push it to make a precedent that changes laws. So that balancing between upholding the current law, which might not be really good for us, might have been passed when we weren't quite as aware of what was going on, and then changing laws at the legislature. Hopefully we don't have to change laws in the court system. We don't want to use the court system to change laws. We would rather do that at the legislature. So today I'll be talking about state laws and a little bit about federal laws. Now, states are responsible for protecting the safety of their citizens. It's called police power. So states really are the ones that decide who can practice medicine, who can practice any profession. If it causes an imminent risk of harm to the public in general, then the state would say, we need to put some restrictions on that vocation or that profession so that only certain types of people can do that dangerous act. So state laws are really responsible. And so there's a blanket of state laws around the country that are all different regarding the healing arts because of how they restrict or regulate the healing arts. Federal laws, and this is just a blanket statement, but not always true, federal laws are generally for commerce, going across state lines for products, what you can say on the label, how they're manufactured. So for the healing arts, The federal laws are very important regarding dietary supplements and drugs. And of course, there's many federal laws and standards for air quality and other things that affect our health. So when we begin, we ask ourselves, are we asking a question under state law, or are we asking a question under federal law? Somebody says, can I sell this supplement? That would be a federal law. But a state law would say, are you helping someone with a health problem? So that would be a practice law. So some practitioners actually are helping someone with a health problem. They are also selling products, and so they're going to have to be versatile in both of those areas of law. So we first started our organization, the National Health Freedom Coalition, because I was working on a case where a state law said this person was a farmer, he was practicing, and they said it was a criminal charge. And the charge was against the practice of medicine. And I thought, how could a regular citizen be charged criminally for the practice of medicine? So I had to do a lot of research. And so here's the state of Minnesota practice of medicine defined. And this is just one of 6 paragraphs. But this paragraph was the most important that I first learned about the practice of medicine issues many years ago. A person who offers or undertakes to prevent or diagnose, correct, or treat in any manner or by any means, methods, devices, or instrumentalities, any disease, illness, pain, wound, fracture, infirmity, deformity, or defect of any person. They are considered to be practicing medicine. And if you do not have a medical license to do these things in this paragraph, it would be a gross misdemeanor. I was quite shocked because our farmer had been telling people that colostrum was good for their immune system, and he was charged criminally. So I want to give you an example of a number of other states that have similar laws. Here is, well, I should tell you first, in Minnesota, after we got the farmer safe, then we went and changed the law in Minnesota. And this is the new law that was passed in 2000, 20 years ago, Minnesota 146A. And we asked for an exemption to that criminal charge for acupressure, anthroposophy, aromatherapy, Ayurveda, craniosacral, and we put all these words in there. And we were just citizens trying to write a law that would make sense for all of us. And we put including, but not limited to. And we put all of these wonderful words into Minnesota statute. And then there was a list of prohibited acts, and there was also a mandate that you give out your name and information about yourself, a client bill of rights. So here is the practice of medicine defined in the state of Washington. Anybody who offers or undertakes to diagnose. Then it goes on just like Minnesota, but then it says real or imaginary by any means or instrumentalities. It's a very broad law, so it doesn't matter what you do in the state of Washington, you could be charged if you don't have a license as a medical doctor. There are exemptions already in many of these statutes that say, oh, well, we don't mean people that are doing religious healing, or each state has kind of a different list of exemptions. Some states say we don't mean family remedies. We don't mean, Massachusetts, it's clairvoyance. Iowa says we're not going to criminally charge people that are giving water from the springs of their farm. So there's exemptions, but I'm telling you what the basic definitions are here. So the state of Maine, the practice of medicine, diagnosing or relieving in any degree. And I just think these state statutes about defining medicine, they're very wonderful for doctors, because then doctors do whatever they can to heal a person. They have a very broad definition and scope. But to attach a criminal charge onto this is quite egregious. So here's the state of Wisconsin, the practice of medicine by any means or instrumentalities. The state of Massachusetts, practice of medicine to encourage the reliance of another person upon an individual's knowledge or skill in the maintenance of human health by prevention, alleviation, or cure of a disease. So this one is extremely broad. It's interesting how unique each one of these are. This is about, this next slide is about the state of Maryland. They have the definition of practice of medicine. It's much like the others, but they've passed, in 12 or 13 states have done this now, passed laws to license naturopathic physicians. And in those physician statutes for naturopathy, naturopathic medicine, they have defined naturopathic medicine, just like the medical doctors define practice of medicine. And in that definition, it says the prevention, diagnosis, and treatment of human health conditions, only patient and disease using only patient education in naturopathic therapies and therapeutic substances recognized by the Council of Naturopathic Medical Education. And another paragraph is the practice of the material sciences of healing, including nutrition, phytotherapy, treatment by natural substances, and external applications. Now, because this is such a broad definition, our organization likes to make sure that they have an exemption for the unlicensed people, just like we put in the Minnesota law. But in Maryland, there is no exemption. It's actually a felony if you practice naturopathic medicine. Anything that falls within that definition would be considered a crime. And so this is a very serious issue, and Maryland really does need an exemption to the practice of medicine, but also the practice of naturopathic medicine. And we do have that exemption in Minnesota for the practice of naturopathic medicine. So here's another one, another example of what states do. Kansas Healing Arts, it says, recognizing that the practice of the healing arts is a privilege granted by the legislative authority and is not a natural right of individuals. Now that statement alone makes me cringe, because I don't agree with that. And many people in our country don't agree with that. There are so much natural talent within the human spirit, mind, body that help themselves, help each other heal. It's an inherent right. And I really hope that someday Kansas can repeal that language. So let's talk about the solutions. Our organization has supported what we call the Safe Harbor Practitioner Exemption Laws, and that is trying to leave the definitions all in place where they are, but pulling out exemptions, conditional exemptions, as long as you avoid prohibited acts, as long as you give out your identification and your background, and you post. Some states have posting of that information in the practice area. So the Safe Harbor Practitioner Exemption Laws are trying to exempt people from those criminal charges without disturbing the definitions that the professionals that want to be licensed have. So here, the latest Safe Harbor bill, which is the 11th one, is Maine. Their new law exemption is the Right to Practice Complementary and Alternative Healthcare Act, sponsored by Senator David Miramont. And we're just so proud of them. It was a group of, first, initially they contacted our organization, and they were a group of homeopaths that wanted to set up a homeopathic clinic. But they were told by someone that they might not be able to do that because they would be considered practicing medicine without a license. So they called us and we worked with them, and they quickly passed a bill. They passed our bill within 6 months. It was amazing how fast it went through the legislature. And Senator David Miramont did a great job of championing their bill. Here's another example of a successful safe harbor practice law. In Nevada, Nevada has licensed medical doctors that are homeopaths. So they not only have a medical practice licensing board, they have a homeopathic medical doctor licensing board. So they were not willing to have homeopathy exempted from criminal charges in Nevada. But we did get everything else in that we could. And hopefully someday the regular homeopaths that are not licensed will be able to practice without doctor supervision in Nevada. So New Mexico, a wonderful state, they put in all of their wonderful modalities and professions. They even included plant medicines, food, prayer, ceremony, and song in their list of exempt services. So now we're moving to, that was an example of states that have already passed safe harbor laws. There's 11 states now. But now we're moving into some discussion about the bills that are current right now. COVID has really changed the climate, of course, in legislatures, and not many things are moving. But there are 2 safe harbor states that are very active, that are still moving, and we hope that they make it through session even during this time in our country. The first one is Massachusetts. It's a safe harbor exemption bill. We've been sending out alerts, and you can see those alerts on our website, nationalhealthfreedomaction.org. And this is a Senate file, Senate 2634. It's already moved through the Joint Health Committee, so it's had a lot of review by legislators. It is in the Ways and Means Committee right now in the Senate. And if it makes it through the Ways and Means Committee, it will be sent to the Senate floor. And then the Senate floor, if it makes it through that, it'll be sent to the House floor. So we're just supporting them, watching, and you can see them on their website as well. The other active state that we have a safe harbor bill in during this time is Wisconsin. And Wisconsin, it already passed the assembly. We had hearings in the assembly. It went to the Senate. We had hearings in the health committees in the Senate, and now it's on its way to the floor of the Senate. So it's already passed the floor of the assembly. It's on the way to the Senate floor, and we're really hoping that it's one of those few bills that get heard this session, probably after the election, to make it through the Senate floor and be passed. We're hoping that Wisconsin makes it through. So congratulations, Wisconsin and Massachusetts, on all your hard work, and we're hoping that you pass by the end of the year. I want to talk a little bit about what we have to offer in terms of how to help people pass bills. We have relationships with a lot of organizations around the country, and we always ask them to jump in and support their state bills as well. This is our website for our Action Lobbying Organization, National Health Freedom Action, and we have 2 attorneys, myself and Ann Gillum. And we really help guide states that call us and want our help. So we do conference calls. Sometimes we do weekly conference calls with state groups. We're doing weekly conference calls with Massachusetts and Wisconsin when we can. We're doing weekly calls with California Health Freedom Advocacy for their vaccine issues. So we do conference calls quite a bit, and they're usually Zoom conference calls now. And we travel. Sometimes we come and we testify. We make presentations for state groups on site. We draft a lot of legislation. We research state laws, and we try and come up with drafts that they can give to their local attorneys to review. And we provide testimony, we provide point documents, but mostly we act not as the people that are actually passing the bills on the ground. We're your support team and kind of showing you how to proceed, what are the important issues to look for, how to choose a sponsor, how to choose a lobbyist, how to research your laws, how to figure out what you want to say in your bill draft. So we try to support your efforts on the state, on the ground. This is an example of what our website looks like when we list the action alerts. So what happens is that if you have a bill that's moving, we have a software that we write an alert saying, here's where the bill is at, here's who you need to write to. And it's a really great program in that we can say, here's a sample letter. You can send this letter if you want to, just by putting in your zip code, and it'll go automatically to whoever you want it to go to, your legislators, or maybe sometimes we target a committee. But the other thing is, if you don't want to send that letter, you can send a different letter and write your own, but it will go directly to your legislator and you don't have to look up who they are. So we actually designed some alerts to go to special committees. Right now we're doing an alert that's going to the Regents of the University of California. So we will target different groups, and then you can send your personal letters to the legislators or the people that need to hear from you. And so these action alerts are all, whenever we put one out, we put them on our website, so they're listed chronologically. And you know, you can go to our website and see what we've been doing. Here's my little design of which states are the 2020 Safe Harbor Health Freedom states. So Oklahoma and Idaho are very old states. They've had some language in their statutes that have some protection. Arizona is limited just to unlicensed homeopaths. They don't have a very broad bill. Like I said, Nevada does not include homeopaths, but the rest are pretty broad. And so they're all different. They all depends on the group working on them, depends on the legislator that takes them forward. But we're really proud of them. And they're all listed on our website. So if you go to National Health Freedom, the regular educational website, and you go into the document center, you'll see all of the language of the safe harbor bills. Every single state's law that has passed is in a list there, you'll see. So this is my handmade map of how I keep track of things. And right now, Utah is just gearing up. They're trying to develop a safe harbor group. We're watching Wisconsin and Massachusetts very carefully. If you're red, that's who you are. And if you're green, you've already passed a safe harbor bill. If you're blue, you've introduced one, but it has not passed yet. And if you're pink, you're thinking about doing that. If you're white, we don't have a regular contact with anyone in your state yet. But we do have contacts. Maybe we'll have one or two, but that we've talked to, but not a group formed. So here's a photograph of some of our leaders at the Capitol in Wisconsin on one of the days where we all went to testify at a hearing for the Wisconsin bill. Here is a picture of the Massachusetts leaders at their Capitol. It was a day that they got a tour by one of their sponsors of the bill. That was a really great day for them. Here are a couple of the homeopaths in the Safe Harbor Maine group. So they were at the Capitol. They in the rotunda, they put up a table and everything to teach people about homeopathy. And here is Jim Jenks from Nature Sunshine on the right, and their lobbyist, Ms. Miller. And that's the Nevada lobbyists that they worked with to get the Nevada bill passed. It was a successful effort. So I just want to say that the state health freedom groups work on many issues. We primarily started with the safe harbor issues, but practitioner rights, vaccine exemption rights, protecting parental choice in vaccines and employment choice, GMO labeling, geoengineering, electronic magnetic frequencies, glyphosates. You know, there are so many issues that go by our screens that affect our health and wellness. And we want to support organizations that support good health and the freedom to make your own health choices. Let me talk a little bit about federal activism. Federal issues, like I said, having to do mostly with commerce. So these are some of the federal issues that we have been involved in supporting or opposing. The dietary supplements, what you can say about a dietary supplement, the health claims issues, homeopathic remedies. There's been a lot of, fear that they're going to the federal government is going to limit homeopathic remedies. GMO labeling, we definitely supported the labeling push. Vaccine mandates, we're working really hard state by state on the vaccine mandate issues to oppose any mandates. Geoengineering, we're trying to educate ourselves about who regulates the climate. And electromagnetic frequencies, since the entrance of 5G small cell antennas that are very close range, we're very concerned about that. So just like the practice of medicine, I put this slide in here because I wanted to see the definition of drug federally, because it's just like the definition of medicine in the states. So you'll see number B, articles intended for use in the diagnosis, cure, mitigation, treatment, or prevention of disease in man or other animals, and articles other than food intended to affect the structure or function of the body. So they're saying the definition of drug is anything you use to cure somebody or to help them. And that used to shut down a lot of people. And then in 1984, we went forward and worked to amend this definition. And you can see in Part C that the little 3 words that are in blue, other than food. So no longer can they call a food a drug and require the drug approval process. So the other than food was the foundational piece in the Dietary Supplement Act to protect dietary supplements. So here is the 1994 drug definition that was revised, other than food. And then they made a definition for dietary supplements specifically: a vitamin, a mineral, an herb or other botanical, an amino acid. You know, these are things that now are protected and are considered, generally regarded as safe. They're not considered, you know, to be inherently toxic legally like a drug. So herbs, there are so many people that use herbs, and there's so many herbalists. Herbs are regulated as foods now. So the dietary supplements are regulated as foods, not drugs, and they are generally regarded as safe unless the government proves otherwise. So that's a really great burden of proof, that the burden of proof is on the government to show harm rather than like a drug. The burden is on the manufacturer to show safety before it can go into the public. So the next other issue that we've been involved with a lot are homeopathic remedies, trying to protect homeopathic remedies. And I looked at what the FDA, you know, how would they answer that? How are homeopathic drugs regulated? And they just had a very straightforward answer, and this is one of the paragraphs. They said, under the Food and Drug Cosmetic Act, homeopathic products are subject to the same requirements related to approval, adulteration, and misbranding as other products. There are currently no homeopathic products approved by FDA. Now, this is a very controversial statement because some people could argue that homeopathic drugs are inherently safe, and they're not drugs, and they've been generally regarded as safe for many, many years. But this is what the FDA thinks about them. So the FDA, because they are not approved, in 1988, they put out a document, a guidance document. They didn't change the law, they just put out a guidance that these are the conditions under which homeopathic drugs may be marketed. Because homeopathy, and if we go back to the definition of drug, I'm just going to go back there for just 1 second. Homeopathics are included in the definition of drug. In Part A, you'll see articles recognized in the official United States Pharmacopoeia, official homeopathic pharmacopoeia of the United States, or official national formulary. So since they're considered drugs and not food like dietary supplements, the Federal Drug Administration still consider themselves the regulators of homeopathic remedies. So they put out this guidance document and said, even if we haven't approved them yet, we know they're out on the market, These are the conditions under which homeopathic drugs may be marketed. So it gave guidance to the manufacturers for homeopathic remedies saying, well, if we stay within this box, they're not going to come after us. But then that happened with the negotiations of some of the homeopathic leaders in 1988. There were improvements to be made on 400, but that was what was existed. And then in 2017, the FDA put out a draft guidance again, and it said, we plan to repeal 400 and shift to a whole different thing. We're going to do risk assessments on all of the remedies out there. And there's a list of risky things, and there's a risk of things that are probably not as risky. They called it the drug products labeled as homeopathic, guidance for FDA staff and industry. And everybody was worried that they were going to repeal 400 and shift to this kind of drug risk assessment issue. So we put in our comments saying, don't take 400. We really need to change the law. We really need to, leave 400 in place until we can figure out what we're going to do. They got so much feedback, but on October 2019, they did repeal and withdrew 400, even against all people's wishes. And they had so much feedback on the first draft guidance that they put out a second draft guidance, trying to take people's considerations into view. But that second draft guidance was almost worse than the first draft guidance, in my opinion, and we lost the protection of 400. In the whole arena of doing this, our organization drafted legislation that would make homeopathic remedies generally regarded as safe, and but we just put it out there as a model so that the homeopathic community could take it forward someday if they want to, and that was our contribution to the fight. So as of today, September 2020, there's no new final revised guidance document. So homeopathic remedies are still waiting. And I looked and it said on the FDA website, it said, is FDA going to remove homeopathic products from the market? FDA says, FDA's top concern is patient safety. When the draft guidance is finalized, it will specify the categories of products the agency intends to prioritize for enforcement. In the interim, before the draft guidance is finalized, FDA intends to apply its general approach to prioritizing risk-based regulatory and enforcement action. So homeopathy is in the crosshairs of having a drug definition, not a food definition, and having the FDA not being considering all of them as generally regarded as safe. So my question always is to all people that work for Health Freedom, who is representing you, and that we need to be at the table long term if we're going to make a difference in health freedom. These issues have permeated our culture, and all of us really need to be watching how, as we evolve technically in the world, we also need to evolve in the protection of our ability to remain healthy and happy as individuals on the planet. Our organization that does the lobbying and the changing of laws and supporting people that do that is National Health Freedom Action. And I am that director, and Ann and I work really hard to support. We also have a support staff that is just tremendous, and a dedicated board of directors that is so wonderful. We can talk through these issues in detail, and we're very lucky to be working for such a wonderful organization. And then the National Health Freedom Coalition is the nonprofit for educational purposes. And we try to give presentations whenever we can and educate people like I'm doing today to talk to you about what we do and what the issues in health freedom really are today. One of the projects of the Coalition Educational Organization is called the U.S. Health Freedom Congress, and it has voting members. And we have held 12 congresses now where we bring leaders from all of the different areas of health freedom together. The dietary supplement people, the practitioner people, the vaccine people, the GMO people, the 5G people. And these organizations are so tremendous. These leaders are so dedicated. We are just honored to bring them together and celebrate health freedom and talk about issues where we can collaborate. Here's a picture of all of us gathered at the St. Paul, Minnesota Health Freedom Congress in 2018. That was our last one. We were thinking about having one this year, but since COVID, we decided we're not gonna do that. But we may have a conversation like a Zoom call or something, but we're still in the process of thinking about that. So to end my presentation today, I'm gonna get a little drink of water here. Thank you for listening. It's been good to be with you virtually. I'm going to share with you a document that we've endorsed at the Health Freedom Congress, but something that I worked on for a number of years called the Principles of Health Freedom. And I think no matter what area of health freedom that you are working in to protect the right of people to make decisions about their own health and the right of people to really get the health that the healing that they want. Here's what the principles of health freedom are for us. We believe that we have a fundamental right of self-determination to be let alone, to survive on our own terms and in our own manner. So even if you're, maybe you're in a nursing home and you don't want invasive treatments and you want to be having nutrients and comfort care, but you really just don't want to do what maybe somebody else thinks you should do. And that can go for a young person too. A lot of people have individuals on what people should do for their own health. We really support that we have always the right to be left alone, to be let alone with our self-determination with our own bodies. Principle number 2 is the freedom to perceive and to act to secure our health. And so this includes freedom of speech, freedom of association, freedom of travel, things that we need to do to access and to actually do in order to get healthy. And so, for example, the freedom to secure health and survival, we might want to access something that somebody else doesn't want us to have. And that number 3 is all about access, the freedom to access who and what we need or prefer for our health and survival. So there are many instances in my history as an attorney of practitioners especially being shut down for practicing something that people wanted. No one was getting hurt, but it was not considered within a conventional standard of care. And also there are people that are forced to get, like children, forced to get chemotherapy, and they want to go to a holistic practitioner, but the authorities won't let them go where they want to go. Principle number 4 is the responsibility to do no harm. So this is a very controversial because the Hippocratic Oath is the foundation of medicine. So to do no harm is a very broad topic because you have a person who is given the right to do harm, like surgery or IVs or putting someone back together after an accident, or chemotherapy, which is toxic. So you have people that are allowed to do harm, but at the same time, you need to keep the conversation going that is there a better way to do this? Is there a way to do this that would not be harmful? So choosing the no harm first is really an essential concept of healing. Like, you just don't harm people when there's another way to do it in another manner. And so that needs more discussion, and that oath is an important foundation to the practice of healing. Number 5 is the responsibility to respectfully tolerate diverse options in health, healing, and survival choices. And this level of tolerating diverse options, this is here because there becomes, when you have a dominant culture, I saw a dominant medical culture, a dominant theory of how health is supposed to look like. If you have a dominant concept, then the hostility rises when someone wants to choose something different. And so the shaming and the anger coming from people that want someone to do the dominant thing is part of the suffering of people that want to have access to alternatives, is that they're not respected in their choices for healing. Principle 6, the duty of corporations or institutions to be trustworthy. And you know, the corporations have and institutions have they have other missions other than your health. So they might have the profit motive, they might have an educational motive, they might, like a educational institution like the University of California right now mandating flu vaccines for all their employees. I mean, they're perceiving their responsibility to everybody as one thing, but really need to know what the corporate motives are and whether they're trustworthy and whether they really have a sense that they also need to uphold health, freedom, rights, and liberties of members. So just because that whole area is so big, we have principle number 7 with 5 sections. In light of the special legal nature of corporate entities and their systemic impact on the human family, they have special duties because they're so large. And so one of them is honor and preserve the sovereign nature of individuals, the sovereignty of the United States, and avoid any negative impact on the sovereignty of other nations. I mean, just the fact that you could go into another country and hurt people from another country with your corporation is an issue. The second part of number 7 is honor and preserve American financial and cultural diversity and multicultural systems. You know, this whole principle, it's like small farmers. I was raised on a small farm. They're disappearing, and that diversity is really, really important in financial ways and also in cultural ways. There are many cultures that have different ways of preserving their health. Number 3 and 7 is avoid creating or being monopolies and using that power to dominate cultures and public policy. Well, of course, we all know that that is happening. And number 4 is avoid dominant control of natural resources, avoiding the suppression of natural resources. You know, we can't allow corporations to just do whatever they want for profit to our natural resources and our air, our magnetic field around the earth, our minerals in the earth, our water supply. You know, it's just, there are so many ways that corporations are now impacting the natural resources. And number 5 actually is my favorite one and most important, avoiding the promotion of products protocols, policies, regulations, or laws that would encourage unlimited dependence on corporations and institutions, or that would discourage, prohibit, or otherwise negatively impact the ability or will of humans and local human communities to survive and prosper without the corporation of institutions or institutions. So you're talking about this giving people something that has a profit motive that might not be good for them, but then creating a dependence on them. And then the persons receiving that think that they can't really survive well without that, and promoting that complete dependence. And I think that has happened in our country in so many ways. But in the health system, I think there is a lot of belief that people only know one way to heal, and that's through a conventional mode. So there's not a real trust that there are many different ways to stay alive on the planet. And then the last principle of health freedom, not just the government's, but the duty of the government to protect health freedom and to make no law or public policy abridging health freedom or its fundamental principles. And this one is squarely in the crosshairs right now with COVID and the executive orders coming from governors making orders that are impacting the ability of us to make our own personal choices for our health. So I want to encourage you, be an agent of change. And I say laws and customs must be carefully reviewed, revised, and even repealed if necessary, and new laws created to reflect the development, evolution, and spiritual maturization of a people. Freedom solutions. A healthy person or community will throw off too much restriction of sovereignty in order to control their own destiny. Our solution, control in the least restrictive means to the point where there is no substance left except the essence of order and harmony. And my last comment to you today is to say that freedom is a conversation. It's an energy. It's there are so many ways to look at how freedom is manifested in the world, and it requires a conversation, because one person isn't the same as the other person, and corporations are not the same as governments, and that participation in the freedom conversation is the essence of how you decide how to be here and survive on the planet. And sometimes people think, I don't need to be in the freedom conversation because everything's fine with me and I'm fine in my house. But everything that you do has to do with freedom and how it got there and who paid for it and how you can live in harmony with all of the impacts of freedom being impacted. So I want to encourage you to participate in the freedom conversation. And I'm so grateful for the opportunity to talk to you today and let you know about our organization, both of them. And I hope we meet you on the Freedom Trail in the future.